Turning now to Las Vegas, Nevada, where closing arguments are about to begin in the protective grandmother murder trial. Retired Detective Pamela Bordeaux is accused of fatally shooting Sean Babbitt 10 times on the morning of April 22nd of 2019. Babbitt shared a 3-year-old son with Bordeaux's daughter and was at his supervised weekly visit with him when the shooting occurred. Before we get you into court as we wait, here's more on the case against Pamela Bordeaux.
Keep walking. Turn around. Turn around. Turn around.
April 22nd, 2019. 55-year-old Pamela Bordeaux, a retired Las Vegas police detective, is arrested outside her home.
What do we got going on inside the house?
Control 652. We get a quick debrief from her before we send the team in to clear the residence.
There's no one else in there that's armed. My daughter.
We got a daughter upstairs with a baby.
Yeah, that's it.
Bordeaux was referring to her former son-in-law, Sean Babbitt.
Is Sean down?
Is Sean down?
Is he 419?
I don't know.
Does he appear like he's dead? Is he moving?
I don't think so.
Sean was divorced from Pamela Bordeaux's daughter, Erica. They had a 3-year-old son that Sean only saw once a week, per the divorce agreement. Bordeaux supervised those weekly visits at her house.
Do you hear any moaning, anything like that? No?
No.
A week before he was killed, Sean had filed papers to amend their custody agreement, and he was seeking more time with his son.
I think for the first time, he stood his ground, and he says, no, I'm getting more time with my son. I don't think she could stand that.
Did you shoot him or did he shoot himself?
Action team ready to go.
Huh? You shot him.
Sean Babbitt was shot 10 times in his head, torso, and hands. His family called it an execution.
He was shot 10 times, and most of them were defensive, and he tried to block them.
Pamela Bordeaux was charged with murder and pleaded not guilty.
This was no execution. If this was premeditated, if this was deliberate, if this was done with malice, she wouldn't have shot this man in her own house.
She claims she acted in self-defense and in the defense of her daughter and grandson. Her defense team says that Sean had a troubling dark side.
Obviously, this young man was dealing with some deviant behavior, and that's why he had supervised 1-hour visits a week and no more.
All right, let me bring in criminal defense attorney, former prosecutor Eric Faddis. Eric, I'm going to tell you that closing arguments haven't started yet. If they begin, I may need to go into court. But, you know, the thing that really struck me is that the defendant, when it first happened and the police had her, she was so calm. But she also has training. She's a retired L.A. police detective. So do you think her calm demeanor meant she planned this and was cold and executed him? Or could it mean she just has the kind of training to know how to defend herself, and it's a little bit different than a layperson?
Judge Esley, it's hard to say, but yeah, and looking at her background, at her career, I'm sure she has come across grisly scene after grisly scene, murders and assaults and everything under the sun. And so whereas for a normal layperson, being involved in that might be jarring and shocking, and they might have this heightened reaction. For her, it at least makes sense that based on her background, she did not have that kind of reaction, and instead, as you said, appeared rather calm.
She did. Well, let's see how she sounded. You're going to compare her speaking there at the scene, Eric, to how she testified on direct examination by the state when she described shooting the victim.
What happens at the conclusion of the hour?
When supervised visitation is over about 8 o'clock, my daughter and my grandson go into the bedroom, we get up, and I go, Sean to open the door. I had Sean to open the door. As I'm opening, do you want me to tell you?
Yes, very good.
As I'm opening the door, I look to see where Sean is. He's halfway down the stairs. Looks like he wants to charge me and strangle. He's charging, and as he's doing that, he has his hands in front of me. His eyes are open wide. His jaw was clenched. I thought he was going to strangle me to death, and then I hear shots fired.
All right, again, Eric, she's fairly calm there as well.
Yeah, I agree. And one thing that's interesting is she kind of knows the details to touch on for a self-defense claim. Why? Because she's probably seen countless self-defense claims as a police officer. So she's talking about the eyes being wide, the jaw being clenched, the arms outreached coming towards her. Those are all sort of boxes you want to check for a valid self-defense claim. Now, whether it's truly valid is up to the jury.
And, you know, I want to also listen to a little bit of the cross-examine because I think the attorney asked exactly what we would all want to know, which is you shot him 10 times. Why not use a less lethal means to subdue him? Let's see what she had to say that on cross.
You also had your pepper spray that day.
That's correct.
And where do you hold your pepper spray?
Inside of my bra and inside between, shove it down.
Okay. And just like every day, you had your pepper spray on you, fair?
That's right.
And you had that in your chest area ready to use if you needed to.
That's right.
Okay. And you also had handcuffs with you that day, correct?
That's correct.
And every time that you have a visitation, you have all three of those items.
That's correct.
You could use your handcuffs to restrain somebody if you neutralized them and then they were still, you know, getting out of hand or a little too violent. You can restrain
the
them.
situation.
Okay. And you had all of those on you that day.
That's correct.
So you had lethal force, correct?
That's correct.
You had non-lethal force.
That's right.
And you had the ability to restrain.
That's right.
All right, Eric, is that what you would have gone after in cross-examination?
I think it's important for the government to establish that she did have non-lethal options. She had less severe options to try and defend herself. That being said, she is likely entitled to use the degree of force necessary to neutralize the threat. Pepper spray doesn't always work the same on everyone. And whether she could handcuff this man who she says was coming to attack her, and she's rather slight in build, you know, that probably went through her head when deciding to use the firearm.
Yeah, I think you're right. Absolutely. We're going to keep our eye on that, and I will report that they are bringing the jury into the courtroom. Eric, we're going to take a break. I understand there'll be some instructions, and then we'll go in for closing arguments. Stay tuned. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for joining us. Closing arguments are getting underway soon in the grandmother murder trial. Retired Detective Pamela Bordeaux stands accused of fatally shooting her ex-son-in-law, Sean Babbitt, while supervising his custody visit in her home with his 3-year-old son. Bordeaux claims she shot Babbitt in self-defense, but the state says no, it was murder. Right now, before they get to the closing arguments, the jury is in the courtroom and the judge is giving the final instructions to that jury. Let's go in.
Considered rational impulse, even if it includes an intent to kill, is not deliberation and premeditation as will fix an unlawful killing with murder of the first degree. 11. The intention to kill may be ascertained or deduced from the facts and circumstances of the killing, which is the use of a weapon calculated to produce death, the manner of its use, and the intended circumstances characterizing the act. 12. All murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with the malice of forethought without the admixture of premeditation and deliberation. 13. You are instructed that if you find the state has established that the defendant has committed first degree, you shall select first degree murder as your verdict. The crime of first degree murder includes the crime of second degree murder. You may find the defendant guilty of second degree murder if 1. You have not found beyond reasonable doubt that the defendant is guilty of murder of the first degree, and 2. All 12 of you are convinced beyond reasonable doubt that the defendant is guilty of the crime of second degree murder. If you are convinced beyond reasonable doubt that the crime of murder has been committed by the defendant, you have a reasonable doubt as to whether such murder was of the first or second degree. You must give the defendant the benefit of the doubt and return a verdict of murder of the second degree. 14. The unlawful killing of a human being without malice expressed in a voluntary sudden heat of passion caused by provocation apparently sufficient to make the passion irresistible. Provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing sufficient to excite an irresistible passion in a reasonable person or an attempt by the person killed to commit a serious personal injury on the person killed. A serious and highly provoking injury which causes the sudden heat of passion can occur without direct physical contact. However, neither slight provocation nor assault or trivial nature will reduce the homicide from murder to manslaughter. For the sudden, violent, impulsive passion to be irresistible resulting in killing, which is voluntary manslaughter, there must not have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard. Or if there should appear to have been an interval between the jury under the facts and circumstances of the case. 15, the heat of passion before reducing homicide. Voluntary manslaughter must be such an irresistible passion as naturally be aroused in the mind of an ordinarily reasonable person in the same circumstances. The defendant is not permitted to set up her own standard of conduct to justify or excuse herself because her passions were aroused unless the circumstances in which she was placed in the past that confronted her were such as also would have aroused the irresistible passion of the ordinarily reasonable woman, if likewise situated. The basic inquiry is whether or not at the time of the killing the reason of the accused was obscured or disturbed by passion to such an extent as to cause the ordinarily reasonable person of average disposition to act rashly without deliberation and reflection from such passion rather than from judgment. 16. If you find that the state has established that the defendant has committed murder, you shall select the appropriate degree of murder as your verdict. The crime of murder may include the crime of voluntary manslaughter. You may find the defendant guilty of voluntary manslaughter if 1. You do not unanimously agree that beyond reasonable doubt the defendant is guilty of murder either first or second degree, and 2. All 12 of you are convinced beyond reasonable doubt that the defendant is guilty of the crime of voluntary manslaughter. If you are satisfied beyond reasonable doubt that the killing was unlawful, but you have a reasonable doubt as to whether the crime is murder, you must give the defendant the benefit of the doubt, and then you must unanimously decide that the state is proven voluntary manslaughter beyond a reasonable doubt. You may not select both. 17. You are instructed that if you find the defendant guilty of first or second degree murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond reasonable doubt that a deadly weapon was used in the commission of such an offense, you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. However, if you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. 18. Deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used or threatened to be used, is readily capable of causing substantial bodily harm or death. You are instructed that a firearm is a deadly weapon. 19. In order to use a deadly weapon, there need not be conduct which actually produces harm, but only conduct which produces the fear of harm or force by means or display of the deadly weapon in aiding the commission of the crime. 20. The killing of another person in self-defense or defense of others is justified and not unlawful when the person who kills actually reasonably believes. 1. There is an imminent danger that the assailant will either kill her or cause her great bodily injury. And 2. It is absolutely necessary under the circumstances for her to use in self-defense force or means that might cause the death of the other person for the purpose of avoiding death or great bodily injury to herself. A bare fear of death or great bodily injury is not sufficient to justify killing, to justify taking the life of another in self-defense. The circumstances must be sufficient to excite the fears of a reasonable person placed in a similar situation. The person attempting to kill must act under the influence of those fears alone and not in revenge. An honest but unreasonable belief in the necessity for self-defense does not negate malice. 21. The right of self-defense or defense of others is not generally available to an original aggressor, that is, a person who has sought a quarrel with the design to force a deadly issue and thus, through her fraud, contrivance or fault to create a real or apparent necessity for making a felonious assault. The original aggressor is only entitled to exercise self-defense or defense of others if she makes a good faith endeavor to decline any further struggle before the moral blow is given. Where a person without voluntarily seeking, provoking, inviting, or willingly engaging in the difficulty of its own free will is attacked by an assailant, she has the right to stand her ground and need not retreat when faced with the threat of deadly force. 22. Actual danger is not necessary to justify a killing in self-defense or in defense of others. The person has the right to defend from apparent danger to the same extent as she would from actual danger. The person killing is justified if 1. She is confronted by the appearance of imminent danger which arouses in her mind and honest belief and fear that she or another is about to be killed or suffer great bodily injury, and 2. She acts solely upon these appearances in her fearing actual beliefs, and 3. A reasonable person in a similar situation will believe herself to be in like danger. The killing is justified even if it develops afterwards that the person killing was mistaken about the extent of the danger. 23. If a person kills another in self-defense or defense of others, it must appear that the danger was so urgent or pressing that in order to save her or another's life or to prevent her or another from receiving great bodily harm, the killing of the other was absolutely necessary and the person killed was the assailant, or that the slayer had really and in good faith endeavored to decline any further struggle before the mortal blow was given. 24. If evidence of self-defense or defense of others is present, the state must prove beyond reasonable doubt that the defendant did not act in self-defense or defense of others. If you find the state has failed to prove beyond reasonable doubt that the defendant did not act in self-defense or defense of others, you must find the defendant not guilty. 25. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind in which the act is done. Motive is not an element of the crime charge, and the state is not required to prove the motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. 26. The defendant is presumed innocent unless the contrary is proved. This presumption places upon the state the burden of proving beyond reasonable doubt every element of the crime charge and the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but it is such a doubt as would govern or control a person.
Still with us, criminal defense attorney Eric Faddis. Eric, the judge started by saying to the jury, I'll talk fast to get through the jury instructions. And boy, she is. But so long as a copy of the jury instructions go out with the jury, I don't think that's problematic.
Yeah, I hear you. I mean, if they
you may
have that
disagree.
copy, then they'll be able to reference it. But this is the jury being advised on the law they're going to have to apply to this case. And when the judge is rattling them off, I know she's trying to be mindful of the jury's time, but I'm just worried that could present at least some degree of error if there's a conviction.
Yeah, I don't disagree. That was my initial first response. The other thing I want to mention, though, is this is an open murder charge. What this means is that it can include first-degree murder, second-degree murder, and all the other lesser offenses that are applicable to these facts. And so it gives the ability for the jury to decide which one of those, if any, the facts of the case prove. It's not always true that there's an open murder availability in states, but here it's a possibility.
Yeah, how convenient for the government that they just get to say, hey, there's like 6 different charges you could choose from. Whatever one you think we proved, choose that one. I think there's a potential unanimity issue there. I don't know exactly if the jurors have to elect or decide on which type of murder charge that they're rendering a verdict on, but unusual, certainly not something done in my home state of Colorado.
No, it's not done here in Georgia either. And I will say, I think that's why that verdict form, talk a little bit about what a verdict form looks like in your experience, because that to me is going to be key, especially when you have an open murder charge.
Oh, 100%. So usually the jury verdict form is where the jury has to physically notate on there what their verdict or verdicts are. And so usually it'll have like a line for the different potential charges, like first-degree murder, second-degree murder, involuntary manslaughter, something to that effect. And then the jurors look at that and notate what their verdict is going to be. But it can get confusing. And sometimes the jurors have questions about it. So we'll have to see if they do here.
Yeah, I agree with you. You know, it is funny. I find you and I are both talking much faster after listening to that judge talk than we typically do, because that's the other thing. You get caught up in an edge of your seat, and I wonder if the jury gets a little frantic listening to it.
Riled up,
right? Riled up. But to that end, she is ready to get to the closing arguments. So we'll take a break, and when those closings begin, we're going to get you back inside that courtroom. Should be any minute. Stay with us.
Wednesday.
The ultimate betrayals.
Back-to-back episodes of Accomplice to Murder.
Spell was broken when the handcuffs went click. Friends and family turning on each other.
What he was willing to do for $1 million.
But just who is the puppet?
She was a master manipulator.
And who's pulling the strings?
An Accomplice to Murder marathon. Starting Wednesday, noon, 11 Central.
Only on Court TV.
Welcome back, and just in time, closing arguments are officially underway in the trial against Pamela Bordeaux. She is facing up to life in prison for shooting and killing her 32-year-old ex-son-in-law, Sean Babbitt, in 2019. Bordeaux claims it was self-defense, but the state says it was murder. Let's go, and now the state has begun their closing argument.
One week ago today, defense counsel stood before you and they told you that this was not a case about child custody. They told you that this was not a case about whether or not Pamela Bordeaux was armed, and it was not a case about how many times she shot her ex-son-in-law, Sean Babbitt. They told you, rather, that this was a case about a frustrated and emasculated ex-husband who was so jealous when he saw that his ex-wife was pregnant with his boss's baby that he, without provocation, without confrontation, and without warning, attacked not his ex-wife, but his ex-mother-in-law on a random Monday in April after an otherwise completely uneventful custody visit. Now, since then, you have heard testimony and you have seen evidence that paints a much different picture. You have heard that Sean was in love. You have heard that on April 22nd, he was happy, he was hopeful, and he was optimistic that he would be getting more custody of his child, and that he had been advised from his attorney that that was a sure bet. You've also heard evidence that not only was he not upset about the pregnancy, he was actually congratulatory about the birth. That's how far he was by April of 2019. So you have to ask yourselves, ladies and gentlemen, why were you told that this was a case about a frustrated and emasculated ex-husband when all the evidence showed the opposite? I'll tell you why. Because if Sean was not in a jealous rage on April 22nd, then he had absolutely no reason to attack Pamela Bordeaux. And if he didn't attack Pamela Bordeaux, and not just kind of attack her, but try to kill her, if that didn't happen, ladies and gentlemen, Pamela Bordeaux is guilty of a first-degree murder. There is not a single bit of credible evidence in this case to support the defendant's claim that she was acting in self-defense. What the evidence proves, beyond a reasonable doubt, is that Pamela Bordeaux acted as judge, jury, and literal executioner in a custody matter when she decided, 5 days after Sean Babbitt sent a letter asking for a modification, when she decided to shoot an unarmed man 11 times in the head, in the back of the neck, in the back of his shoulder, in the back of his arm, and multiple times through his chest and his abdomen and his hands, literally hitting every vital organ along the way. She then waited 26 minutes in that house before she allowed medical in or police in to render aid. 26 minutes. And what do we know that she did in that 26 minutes? She removed the sock from a dead man's body and manipulated that crime scene. And that, ladies and gentlemen, is a cold and calculated, premeditated, and deliberate first-degree murder. It has been Mr. Palal and my job throughout the course of this trial to prove two things to you. First, to prove that crimes were committed, and next to prove that the defendant, Pamela Bordeaux, committed those crimes. Now, the second of these is obvious, right? She's admitted that she is the person, I mean, begrudgingly, she admitted it, but she admitted that she is the person that delivered each and every one of those shots into Sean Babbitt's body. She's the person responsible for his death. So what crime is she facing? Murder with use of a deadly weapon. And this is the place in the trial, ladies and gentlemen, where you're going to look back on all of the facts that came forth through this trial. You're going to couple it with the law that the judge just read, and that will be the tool that you use when you go back and deliberate to come to the appropriate verdict in this case. So you will look at exhibits by way of video, by way of photographs. You will recall testimony by way of each and every witness that came up here. And most importantly for this case, you will employ your common sense that you came into this courtroom with as everyday men and women. Before we talk about what this case is, let's talk about what this case is not. This is not a case of self-defense. Under no circumstances can the story that you heard from that witness stand yesterday justify the taking of another human being's life. Under no circumstances. And we know this two ways. We know this because we're going to use our common sense, and we know it because of the law that you all took an oath to follow. Self-defense is a justified killing. Now you can imagine that there are laws surrounding self-defense, right? And that these laws are very narrowly tailored. Because what we're saying is you are justified. You are justified in killing a human being. You are justified in taking another human being's life. We're going to allow for that, right? And we want to allow for that because if you are in imminent danger, if it is absolutely necessary in order for you to not be killed, we want to carve out an area within the law that allows a person to protect themselves or their loved ones, but it is very narrowly tailored. And if you're wrong in your analysis, and if you're wrong in your assessment, you are guilty of a murder. Common sense. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Let's look first at how our common sense tells us that this attack never even happened. She was never in fear. She was never in danger. He never attacked her. He had absolutely no reason and he had absolutely no motive to attack her on this particular day in April 3 years after these visitations had begun. By her own admission, he never had done this before. By her own admission, there had never been an incident in nearly 156 visits. This day, the only thing that was different about April 22nd is that she knew that he was going to get more custody of his biological child that he had a legal right to. She could not give you and did not give you a single reason yesterday of why this man attacked her. Common sense tells us that he never attacked her because he wasn't even upset about this pregnancy. To suggest that 13 months later, okay, Erica had to go through the entire gestational period. The baby was born in December, and then 4 months later, that he just randomly attacked her. That defies all reason and logic. We know that he wasn't taunting her the week before. She told Marcus that she was being taunted. They didn't even speak. There was no taunting. There was no provocation. There was nothing. We know that there was no interaction and no reason for him to attack her. We know that going into April 22nd, he had high hopes that he was going to see more of his son. Why would he risk it? Why would he go through this? Going there every week when they set up these custody arrangements at 7 a.m., one of the most inopportune times that somebody could meet with their child. Come over, we'll provide an hour for you to meet with your child while I sit there with my gun and my handcuffs, and my pepper spray. You can come at 7 a.m. on a Monday morning. He finally petitions to potentially get a modification, and that's the day that he's going to attack her. He was in love on April 22nd, and he was in great spirits.
My gift is my song, yeah. This one's for you. You can tell everybody this is your song. It may be quite simple now that it's done. I hope you don't mind. I hope you don't mind. Now I've put down in words how wonderful life is on your own. Happy birthday, Shelby.
How wonderful life is. The irony, ladies and gentlemen, that is the song that he chose, having absolutely no idea that his own life would be over within 2 hours of sending that. Common sense tells us that Sean never attacked the defendant. Per Erica, it was a completely normal and uneventful visit. There was no fight. There were no words exchanged. There was no provocation. There was no confrontation, nothing out of the ordinary between 7 a.m. and 8 a.m. And yet shots are fired before Erica even gets to the toilet of that bathroom area. Immediately, instantaneously, as Sean Babbitt walks down those stairs, shots are fired. Erica did not hear anything before the shots. She didn't hear a yell. She didn't hear a struggle. She didn't hear Pamela calling for help. She didn't hear anything because none of that happened, just shots fired. Sean knew that she was armed with a gun and pepper spray, and he was not armed on that day or any other day. Is it reasonable? Does that defy common sense and logic? That someone who knew that this woman was trained in the military, 23 years in law enforcement, that he would just come with his arms outstretched in a manner as if he's going to choke her, knowing he's not armed? Common sense tells us it didn't happen. We know it didn't happen because he never got within 18 inches to 2 feet of her. There's no soot, there's no stippling, there's no struggle. This didn't happen. The way that she describes this with him running down the stairs, momentum alone would have taken him into her. That is an extremely small space. You see it in pictures, you see it in body cam. You can tell from the angle of the stairs and the distance between the stairs and the front door, it could not physically happen the way that she described it. And what else do we know? We know that Sean Babbitt left that home in a body bag. Yet Pamela Bordeaux left without a single scratch, without a single bruise, without a single abrasion, without any blood, without any bodily tissue or fluid, because she never got close enough to him, because he was never, ever, ever a threat to her. Common sense tells you that he never attacked her, ladies and gentlemen, because he was shot in the top of the head.
Use your common sense. All right, thank you to Eric Faddis for joining me this hour. Of course, Michael Ayala joining me next for more closing arguments in the protective grandmother murder trial. Stay with us, Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are in Las Vegas, Nevada this afternoon for closing arguments in the protective grandmother murder trial.
And Pamela Bordeaux's former son-in-law, Sean Babbitt, was at Bordeaux's home on the morning of April 22nd of 2019 for his weekly supervised visit with his son when he was fatally shot by the defendant.
Now, Bordeaux took the stand yesterday where the retired detective admitted to shooting Babbitt, but she says she did so in self-defense. Now, the state says Bordeaux had motive to kill Babbitt, who she shot a total of 10 times.
Right now, we want to get you back into court. It's the state's closing argument. We hit that pause button. Let's go back in.
And that can never, ever be self-defense. You cannot shoot a human being 3 times through the back and then walk in and claim self-defense. It didn't happen. Additionally, the scene tells us it did not happen in the way that Ms. Babbitt described. There is blood spatter on that wall above his shoes, and there's biological tissue with a hair on that plantation shutter directly behind those stairs, because he was shot as he was going down or already down those stairs. He's shot from above, he's shot in the head, he's shot in the back. Now, even if you want to analyze this case in the light most favorable to the defendant, this is where the law comes in. Even if you want to believe that she left him upstairs and then she went downstairs, when everything that we've heard about her and these supervised visits would tell us she would never do that. She would never do that. Even if you want to believe that she turned her back to this man, that the same woman who carries a gun and pepper spray and cuffs, the same woman that carries a baton to the grocery store, you want to believe that she turned her back to Sean Babbitt. Okay, even if you want to give her that, even if you want to believe her story that she was able to do this quick draw and then shoot from the hip in this tiny enclosed space, that she was able to create and then keep that much distance between the two of them. Even if you want to give her the benefit of the doubt and believe all of those things, the law comes in and says she's not entitled to self-defense. The killing of another person in self-defense or defense of others is justified and not unlawful when the person who kills actually and reasonably believes that there is imminent danger that the assailant will either kill her or cause her grave bodily injury, and that it's absolutely necessary under the circumstances, okay? It's an and, both of those things. Now, some of these instructions will talk about self-defense versus defense of others. She never even said in her testimony yesterday that she really had this honest belief that he was going to be able to go back upstairs, get through that doggy door, hurt Brandon or Erica in some way. So the instruction would apply if she was trying to defend herself or others, but that's where that defense of others comes into play. She was never in imminent danger. What we know is that Sean was unarmed. Not only was he unarmed, but the defendant knew it. She knew that he did not own a firearm. He was not a gun owner. She had never seen him armed, and they were never close enough. We heard this kind of implication that, well, she's this small woman. You know, she's 5'2", and he's this man. She was in the military, right? Her height never precluded her from being in the military. She was in law enforcement for 23 years. Her height never precluded her from being in law enforcement for 23 years. Okay, her height, her gender, those kinds of things are irrelevant. She was armed to the hilt, and he was not, and she knew it. She was never in imminent danger, even if you want to kind of, give her some credibility of this story where he's got his arms out, trying to get her for no reason, and not really even understanding the position of how he's doing that. It was not absolutely necessary under the circumstances. Pamela Bordeaux had choices, and she had lots of choices. Lots more choices than many people have in a situation like this. She could have held him at gunpoint. She knew how to do that. She could have used non-lethal force by way of the pepper spray. She could have even neutralized him, immobilized him after she shot him maybe once, and then used those handcuffs that she takes everywhere in order to detain him. She had everything available to her. She knew how to use everything that was available to her. She could have fought, she could have screamed, she could have opened the door. She wants you to believe that she was able to do this quick draw of her gun, back up, do all of this dexterity. She could have then opened the front door at that point in time, right? And screamed or run out the front door if she's that quick. She had many other options, but that's not what she did. What she chose to do is what she had planned to do and what she wanted to do, which is kill Sean Babbitt. That was the choice that she made because that is what she wanted to do. Self-defense, not only must it be absolutely necessary, but the slayer must in good faith endeavor to decline any further struggle before the mortal blow was given. And what do we know here? Let's look at the testimony from the Yatskos. Independently, both of them heard two different sets of bangs or pops. They hear one distinct set. One of them describes it as bangs, one of them describes them as pops. But the import of their testimony is profound. Both of them hear two sets, which means there's a pause in between. One followed by another distinct set, which means she delivers 3 to 4 shots, there's a pause, and then another set of shots. She finished him off. She is not entitled to self-defense. She then waited 26 minutes before somebody could come in to render aid. Additionally, a bare fear of death or great bodily injury is not sufficient to justify a killing. If anything, what she described yesterday, if true, which we know it isn't, would be a bare fear of death. Nobody could seriously take that to a self-defense argument, that she was in imminent danger, that it was absolutely necessary. And the person attempting to kill must act under those fears alone and not in revenge. And what we know, if there's one thing that we know about this killing, is that it was an act of revenge. It was an act of revenge for Sean Babbitt, finally, after all of these years, having the audacity and the nerve to attempt to get more custody of his son. She is not entitled to self-defense, even, ladies and gentlemen, if you analyze this case in the light most favorable to her. What else is this not? This is not voluntary manslaughter. As the judge read to you, this is an open charge of murder. That means that she could be found guilty of first-degree murder, second-degree murder, or voluntary manslaughter. Let's talk about voluntary manslaughter. This is not at play by the defendant's own admission. This is basically a sudden heat of passion caused by a provocation apparently sufficient to make the passion irresistible. According to her, there was nothing going on that morning, right? According to her, she goes to open the front door, she turns around, and she's stunned by his face and his arms and his behavior. This is not a voluntary manslaughter. A voluntary manslaughter is a man walks in and his wife is in bed, with someone who's not him. He has a gun on him in a heat of passion. He shoots her. He kills her because he is so overcome at that moment by what he has seen and by this sudden provocation. That is not what we have here. It's not at play. The defendant, she didn't even say this yesterday. This was not part of her testimony. So what do we have? Murder with use of a deadly weapon. Let's talk first about a deadly weapon. I'll take it straight away. You were instructed that a deadly weapon is a firearm, obviously, right? If you use a firearm in a certain manner, the way we did here, it will cause death, it can cause death, those kinds of things. But the law makes it easy because you're instructed that a firearm is a deadly weapon. So what is murder? Murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Express malice is the deliberate intention to unlawfully take away the life of a human being, which is manifested by external circumstances capable of proof. So, an unlawful killing, that's what we have here. It's not justified. With malice aforethought. So what is malice aforethought? Malice aforethought is the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation. So it's the condition of the mind, right? And it may arise from anger, hatred, revenge, particular ill will, spite, and grudge. This is malice aforethought personified in this case. When Pamela Bordeaux shot and killed Sean Babbitt, she was filled with many, if not all of these. We heard from Marcus, and he told us how she was feeling over the weekend. We know that she was extremely angry about this. We know that she was extremely upset about this. All murder which is not murder of the first degree is murder of the second degree. So by default, we're at a second degree murder. But why is this a first degree murder? It's a first degree murder because we have the admixture of two important elements, premeditation and deliberation. So murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. And all three of these elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first degree murder. Willful, deliberate, and premeditated killing.
All right, Michael, as the closing argument, she's gone through what this isn't, and to say it's not self-defense, it's not voluntary manslaughter. Now she's saying it was cold, calculated, premeditated, deliberate, first-degree murder. Compelling?
Yeah, I think she has. I think she's laid out a case for it if you don't buy the story of the defendant. The way she's laid it out, and particularly the one thing that I think jumped out at me was she's claiming that she deviated from her habits. She was a very regimented person, which she admitted on the stand, and that shutter on the door was down. If you believe that, if that sort of lines up with the idea that she was planning to do it, fits into murder one.
But also those 26 minutes in between the shooting and when she let police and EMS and allegedly manipulated the crime scene, I think that's cold and calculated if you believe that.
Sure enough.
All right, let's take a break. When we come back, we hit the pause button. We'll get you back in for more of the closing argument.
Tonight on Closing Arguments, a deep dive into the case against Karen Reed. We're breaking down the biggest moments so far and looking ahead to what's next.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Ion kicks off the National Women's Soccer League, airing all season long.
She scores! She's on fire! Wow!
See the full schedule and find where to watch at IONNWSL.com.
Turning now to Las Vegas, where closing arguments are underway in the protective grandmother murder trial.
Retired Detective Pamela Bordeaux is accused of fatally shooting Sean Babbitt 10 times on the morning of April 22nd of 2019.
Babbitt shared a 3-year-old son with Bordeaux's daughter and was at his weekly supervised visit with him when the shooting occurred.
Let's get you back into court now for more of the state's closing argument. We're going to pick up where we left off.
I want to talk about motive quickly, real quick. Don't confuse intent with motive. Motive is what prompts a person to act. Intent refers to the state of mind. And the state doesn't have to prove motive because we wouldn't necessarily always know what the motive is for a person when they act. In this case, we do know. And we have known since that first dispatch went out in the early morning hours of April 22nd. This is a child custody issue. The defense talked in the opening about how the state never knew their motive, and the state always thought that it was insurance, and that there was some confusion about that. Let's not be confused about that, because that was never the motive. We didn't discuss it in opening, because it was never the motive. Detective King didn't even know about it until December of 2019. The only reason that that was relevant is because It showed the completeness of his investigation, that he looked at bank records, that he saw that there were payments made out to Voya, that he heard from the family that a claim had been made. It was part of the investigation, but certainly it was never motive. It is a side effect that potentially, it's a benefit, right? When you kill someone, you get money. But it was never a motive of the state. The motive in this case has always been child custody. So let's look at intent to kill. Look at the weapon that was used, the instrument that was used in this case, a deadly weapon, a firearm. Just because you shoot a firearm doesn't mean that you have the intent to kill, but how you use it and how you shoot it certainly matters. In this case, she shot him 11 times. Now, there's been some back and forth. The medical examiner said that there are 11 entry wounds. Ms. Babbitt said yesterday she had fired the gun with 10 bullets in the magazine, or in her gun. So 10 or 11, regardless. The medical examiner said 11 entry wounds. She shot him through the top of the head. Each and every one of these is a manifestation of her intent. Each and every time she pulls that trigger. She shoots him in the back of his neck, in his back, and the back of his arm. She shoots him numerous times throughout his body, to include his chest, to include his abdomen, to include his hands. She absolutely had the intent to kill. She hit him in his head, in his neck, in the heart, in his lungs, in his abdomen, his hands, every vital area of the body. And what's most important about this is that she didn't miss a single time. Yesterday she had this kind of testimony that she was disassociated, right, during this. But she certainly never missed a shot. She knew exactly what she was doing. She shot to kill. Deliberation is the process of determining upon a course of action to kill as a result of thought, weighing the reasons for and against the action and considering the consequences of the action. Now, deliberation, kind of weighing the consequences for and against. You're certainly not making a list. You're certainly not doing an Excel spreadsheet that kind of like puts out the for and against, the pros and the cons. This is something that can occur instantaneously. Premeditation is a design, a determination to kill, distinctly formed in the mind by the time of the killing. I'm going to give you a real-world example about premeditation and deliberation, and something that certainly doesn't rise to the occasion or the topic of murder, but it is something that we do every single day in our lives where we premeditate and we deliberate. You all drove to work today. To jury duty today. And as you, one of us drove to work, as you drove down to the courthouse, you came along streetlights. When you're driving up to a street light, you will see the light is green, and as you're driving up, it turns yellow. So what do? You go through a process of thought. You weigh the consequences for and against what you're going to do. Are you going to slam on your brakes such that someone's behind you? Are you going to step on the gas such that you speed through it? If you speed through it, is a police officer around? If you speed through it, will someone come and T-bone you from one of these other sides? You make an instantaneous decision. You instantly weigh the consequences for and against what you're going to do. And then you make a decision. And that decision is made in your mind by the time you do it. So that's kind of an everyday example of premeditation and deliberation. What do we have here? Erica got the letter from Sean's attorney on April 15th of 2019, and we know that she was extremely angry and she was upset on Saturday night. She expressed her disgust with the family court system and their desire to have some kind of shared custody between mother and father. She knew at that point that she was losing power and she was losing control. She had had control over this situation for 3 years, and Sean Babbitt went with it. She knew that outside of her home and outside of her setting the rules, once this got into the family courts, she was out of control. The determination to kill must have been formed in her mind at the time of the killing. So if it was formed in the mind when she read that letter from Danielle, or when Erica read that letter to her, that is premeditation. If she decided to kill Sean Babbitt over the weekend, as she sat and talked about that with Marcus, and she thought, nah, I'm not going to go through this. We're not going to go through the family court system. I'm going to take care of this. Premeditation. If when Sean arrived on the 22nd, before he arrived, she decided, you know what, he's gonna come over, but he's never gonna leave. That determination to kill was formed in her mind at the time of the killing. And what do we know about April 22nd? We know that every time before the 22nd, she was a creature of habit. She had a habit, she had a routine. Every single time he came, he rang the doorbell, those plantation shutters were closed. She came down and she snapped him open. She looked and she had verified that it was him. She let him in. Of course, she didn't say hello. Of course, there was no niceties, nothing. Okay? Not even the courtesy to say hello. He walks in, they have their 7 a.m. to 8 a.m. visitation. He leaves, and what does she do? She watches him. She snaps that closed. She, by her own admission, is a habitual woman, a creature of habit. She did it on April 1st. She did it on April 8th. She did it on April 15th. But then we get to the 22nd, and what did she say? Oh, on that day, I'd forgotten, I hadn't even put it up yet. No, that is not a coincidence. There are no coincidences in Pamela Bordeaux's world when it comes to how she regulates her life. This is not a coincidence. This is premeditation. She knew before he came that day that she was going to kill him. How do we know? His biological tissue, his tissue with a hair in it, is on that plantation shutter. She closed that window because she knew that when he was going down those stairs, she was going to kill him. And the evidence is on the backside of that window. There is blood spatter as he comes down the stairs, and there's that one hidden casing underneath that shoe that slipped under there. If you're not quite sure about that, if the determination to kill was formed at some point during the visit, it's premeditation. If at some point when he got up to leave, it's premeditation. If when he got to the bottom of the stairs, she made her decision, it's premeditation. If the determination to kill was formed in her mind right before she pulled the trigger, instantaneous thoughts of the mind. By the first time, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th. Certainly by the 11th shot, she had determined in her mind that she was going to kill this man. 2 sets of shots, she finished him off. She then sat in the house with Sean for 26 minutes. 26 minutes. When she came out, finally, and medical and police were able to go in and render aid. What did she say?
With a PR. 776. What do we got going on?
There's no one else in it that's armed.
We got a daughter upstairs with a baby?
Yeah, that's it.
That's the only people in?
Yes.
Is Sean down? Is Sean down?
I don't know.
Does he appear like he's dead? Is he moving?
I don't think so.
Do you hear any moaning, anything like that? No?
No.
Is he holding the gun or is it near him?
My gun.
It was your gun, where's it at? Did you shoot him or did he shoot himself? Okay. Did you shoot him or did he shoot himself? You shot him.
She absolutely knew it.
All right, we'll step aside here, hit the pause button, take a break. When we come back, the remainder of the state's closing argument. Keep it here on Court TV. Welcome back to Court TV Live. Michael Ayala here with Judge Ashley Wilcott. Now, before we head back into court, we have new developments in the Murdaugh family saga out of South Carolina.
Buster Murdaugh, the only surviving son of convicted killer Alec Murdaugh, has filed a defamation lawsuit against several media companies for documentaries they produced about his family.
Now, while Buster took no issue with the content regarding the murders of his mother and brother, he does accuse Warner Brothers, Netflix, Gannett, and Blackfin of alluding to Buster being the murderer of 19-year-old Stephen Smith and insinuating that the two had a romantic relationship.
Buster claims his reputation has been irreparably damaged and that he has suffered mental anguish. He is now seeking actual damages, punitive damages, as well as the cost of the lawsuit. Of course, we'll bring you any new developments as those come in. But now let's get back to the grandmother murder trial.
All right, retired Detective Pamela Bordeaux stands accused of fatally shooting her ex-son-in-law, Sean Babbitt.
Bordeaux claims she shot Babbitt in self-defense, but the state says no, it was murder. Right now, we're listening to closing arguments from the state. Let's go back in right where we left off.
And while she was waiting, and while she was there, she took a sock off of a dead man's body, and she manipulated the crime scene. It is the only explanation, ladies and gentlemen. The sock has blood on the underside of it. Sean Babbitt's feet do not have any blood on them. There is no blood near them. There is no blood from the waist down at this entire crime scene. He didn't step in it or walk in it before he fell. She took the sock off of him and she used it. She used it to manipulate the crime scene. What we know is that this crime scene is completely inconsistent with how she described what happened to her. Okay, we know that there are no bullets over by the blood spatter and the casing, the way that she claims that she's shooting into that wall, from where the body is into the wall. Okay, we know that all of those cases would not naturally pool in that area. And coincidentally, the only cases that are not kind of pooled in a perfect little area in a room that has this much angles and walls and windows, the only ones that aren't there are hidden under the shoes, under the door frame, and under the body. The only explanation for her taking a sock off of a dead man is because she manipulated this crime scene. This case, ladies and gentlemen, is about a father. It is about a father who dared to get more custody of his own biological child. And is it about Pamela Bordeaux, a woman who made a unilateral decision that that wasn't going to happen. She made a unilateral custody decision for Erica, for Sean, and for this child. That he would never have a relationship with his father. Not that his father wouldn't just have custody, but that he would never have a relationship with his child. She made that decision for this entire family, and because of that decision, she is guilty of a first-degree murder. Thank you.
Mr. Trump, did you need a few moments to organize your notes, or do you want to proceed?
Sure.
Okay. We'll take a short.
Joining us now, trial attorney Wendy Patrick. Wendy, you know, one of the things that really stands out to me, I think it was a very compelling closing argument, but that 26 minutes after 10 shots were fired before she ever let anybody in, the police, the EMS, the manipulation of the evidence with the sock, all of that to me screams cold and calculated.
You know, and I could probably give you an additional list of items. You know, it was just jam-packed with facts. And that's one of the things that juries really care about is, you know, they love to go in the back and sort of deliberate over cases that are this complicated in terms of there being a lot of moving parts at a scene and no surveillance footage. We're used to having video footage of everything. But here that actually that crime scene was brought to life through those details, the time frame, the trajectory of the bullets, what was found after the fact, what was supposedly moved. And you'll notice that the prosecutor continually said, quote, the only explanation. Remember, the jury instruction talks about reasonable explanations of the evidence. Here, arguably, the argument is they have more than that. They have only one explanation, albeit one reasonable explanation, definitely, of the state of the evidence. Another thing, Ashley and Michael, that I thought was very important to point out is it's true that motive is not an element of murder, but to a jury, motive matters. So if you got it, great. And that was one of the things that was argued here today. So really the defense is going to have to sort of come back and rebut why there wouldn't have been a motive, why somebody who was ironically singing how wonderful life is, talk about personalizing the victim to the jury, would all of a sudden commit this crime.
You know what, Wendy, you talk about a list of, you could give us a few more. I wrote down, mine is 10 deep. I got 10 things that sort of just point to the fact that this was a killing. But here's the question I want to ask you. She highlighted, I thought, a pretty good case for first-degree murder, that this was premeditated. Now, one could say, you know, that maybe this was malice aforethought on some level, but I thought, particularly, and I mentioned this earlier, pulling that shutter down, if you want to believe that, and she really comes across as a regimented person, so I buy it that she's regimented and habitual. By pulling that thing down when you never see it down in the other videos, I thought she made a compelling case for first-degree murder.
Here's why, Michael, that gets tricky. And I've tried lots of murder cases where that's been the issue, is what does premeditation mean? And the reason it's so hard to prove, probably harder to prove than most people think. I mean, the jury instruction says you can premeditate in a very short period of time, but that hasn't been jurors' common experience in the movies and social media and all the ways in which first-degree murder is portrayed. So we almost approach that analysis and the closing argument, understanding that jurors are probably going to be expecting more evidence than we have to prove premeditation. And that's one of the reasons that there's always this fear that you're not going to get all 12 to believe that premeditation, even though legally can be done in a very short time frame, that's always going to be easy to prove. But I do think that in a case like this, as you point out, Michael, there are those pieces of evidence that you would be able to point to. And that's why, you know, when you got some leadership back in the deliberation room, that's probably going that's probably going to be one of the main things that they talk about, is whether or not there's enough to get to first degree. So it is good, as you point out, all those little details are actually quite significant when they analyze that premeditation instruction.
Yeah, I couldn't agree more. And Judge, I wonder if they might get that premeditation from the amount of shots. Yeah. Meaning you shoot a certain amount of shots, he's neutralized, but then you shoot him more. You can certainly find premeditation in that area as well.
And although she testified about it, she didn't use handcuffs, she didn't use pepper spray. She went right for that gun and 10 shots. Yeah. I agree with you. All right, let's take a break. When we come back, though, the defense closing argument, we're going to bring that to you in its entirety. Stay tuned.
Tonight on Closing Arguments, a deep dive into the case against Karen Reed. We're breaking down the biggest moments so far and looking ahead to what's next.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Friday nights, the WNBA is on ION.
If you ask around, I'm a legend.
This week, the Dream hosts the Fever.
Takes the pass, scores!
Then the Sun battle the Aces. Coverage starts Friday night at 7. ION, it's on.
Back now to Las Vegas, where closing arguments are underway in the trial of a grandmother accused of murdering her ex-son-in-law. The prosecutors say defendant Pamela Bordeaux shot and killed Sean Babbitt over a child custody dispute back in 2019. However, Bordeaux claims she shot him in self-defense.
Let's get you back into court now. The defense beginning their closing argument.
Well, maybe old school on this. And we kind of been through a long trip together, all of us. At the beginning of this case, we talked, right? We asked each other questions. We shared conversations. You told me you would consider all of the evidence, everything, right? Not just that this case was about, well, now it's 11 shots, right? That's not what the experts said. Right? So right after that, I give this credit. I give the state credit. And I'm glad she used the word common sense. Because what you're going to find is that the best evidence the state gave in this case is Mr. Fleck's testimony. That's not evidence. That's stretching. Right? For the first time, to my knowledge, right, 6 years. This didn't happen a month ago, a year ago, 6 months ago. 6 years, right? We see an allegation that the scene has been tampered with. right? And now, miraculously, it's Pam. She must have tampered with the scene, right? Despite the fact that each and every one of the CSAs or the detectives, well, I mean, only one of the detectives were in the house, right? You heard, right? One detective, the lead detective, in control of everything, took a little peek through the threshold. That's all he did. That was his investigation. And despite that, within 1 hour, he came to the motive. He came to his conclusion. Remember, right, when we first talked, we talked about 2 ways of solving problems. Right? We talked about having a conclusion. Right? Forming that immediately. And making that, making all of the facts fit. And then not showing you everything else. Don't look here. Don't look here, because here is where we're in trouble. You know how I knew they were in trouble? Right? Is because on the last day of trial, right? Not the first day, not through any of the detectives, not through the CSAs, did they come up with this concoction, right? The scene has been altered, right? Forget the fact that they all testified that they probably altered it themselves, kicked around shells. One of them even said they kicked around corners, if you can believe that, right? But no, now, despite no reporting, despite nothing to support this theory, right? The scene's been altered, and it's Pam. That's not the way it works in this country, folks, right? You all told me to give her a fair shake. Doesn't that seem kind of odd? Don't you think that if they had that, and that was their theory, their thought, right? Day 1 of trial, the opening statement said, shoving it up by you know what, right? Calling me out, calling Pam out. Instead, they wait to the very end to continue to try to trick you. And they try to get it in through the suggestion is flat. There's no real evidence. Nobody testified that. In fact, right, the detective, right? Now Detective Grant, at the time she was part of the agency, Kiger, right? Her assessment. Then you gotta go with, right? She is a detective now. At the time, she was on the entry team patrol. One would presume she made her way up the ranks because she had a good instinct. Got promoted, right? A good sense, right, of how to assess a crime scene. That's why she's a detective. Her initial assessment that day, right? Again, this is part of a snippet of a body cam that I had to fight to show you. Part of it. You know what went on here. You know what went on. They want to paint a picture on one side, a pretty picture of a happy guy who's in love. You know. I'm so glad. It is fantastic that Ms. Fleck asked you to use your common sense. I'm going to ask you to do the same thing. You can use your life experiences, your common sense, to know that something's missing, right? Who is shaking their tail feathers every time I try to get close, right? You know it, and I know it, right? And we're gonna let them know it soon. And there's so much more. There is so much more here, right? This is, right?
This was close.
Right. That's what they let me get in. It's just enough, right? Just that. That is now, you heard from her. They brought her back to try to clean up their mess. Right? After I brought this out, right? Her perception was fresh that day, not 6 years later. Not after the state prepped her, told her what to say, reviewed the body cam, right? That's fresh, that's on the scene. This was close quarters, right? It appeared to her, Officer Kiger, now Detective Grant, right? This is close combat, right? 11 shots, 10 shots, right? Their medical expert talked about 10 shot. She didn't even agree. In fact, it wasn't even the original person who examined the body. It was a substitute medical examiner. Right? And she really didn't, she kind of didn't like the report, it seemed. And right? She said, well, I don't know if I agree with some of the findings. She went with it, that was her report. Right? And she did not. You all saw me, you know, I'm not super fleet of foot. Right? I'm a big guy, I'm getting old. Right? But she agreed, right? There is no other logical conclusion as to how one would get a graze mark on this side of your hand, unless you were attacking, right? There is no other way. The idea that this crime scene stays is a farce. It's a red herring, right? It's a last-minute ditch effort to convince you that Pam did this. Pam, like I told you in closing for our openings, I told you several things. I told you a little bit about Pam Bordeaux. You heard from her. She had nothing to hide. She told you, I know the big question was, well, why so many shots? Right? And I love the state, right? I love the system. And my client was part of the system, right? She was trusted by this community. 23 years. She made her way up the ranks to detective, right? And she was detective in domestic violence, detective in missing persons. Domestic violence are among the most violent, among the most heated. Think about it, right? People losing their cool, guys hitting their gals going crazy, guys cheating, people fired up, right? And what did you hear from her? You didn't hear any rebuttal, right? She has not fired her firearms in the line of duty ever on anybody in 23 years of service. Think about that. You can use your common sense and form an opinion, right? And what that tells you. Not one incident in 23 years. That's who she is. She takes precautions. You saw her on the stand here. You saw me ask her the questions, right? And then you saw this, right? Salivating, right? Angry, right? Just because she yells doesn't make it fact, right? That's what she does. She's a great lawyer, a good friend. That doesn't make it truth. That's not evidence, right? What you have to go back there and think about is what is evidence, right? Not what Ms. Buck said, not what Mr. Paul said, right? Not the over-exaggerations, right? And the hiding. The blatant hiding of what you know exists, right? Because you look at Mr. Babbitt, right? And this is my job. It's not the easiest job. I enjoy it. I enjoy getting to know people like you. I enjoy my comrades. I enjoy, right?
All right, still with us, trial attorney Wendy Patrick. Wendy, I wrote down, before you even started, I said, common sense doesn't hold up. And he's exhorting this jury to use their common sense. I don't know, tell me how you think he's doing so far.
You know, I noticed the very same thing, is it started with that, and then wouldn't you know it, both sides are talking about common sense. I think he's arguing reasonable doubt in a lot of different ways, both explicitly and implicitly. He's talking about there being more to the story as if that provides reasonable doubt. It doesn't. There's always more to every story. There's always more that to even witness testimony, because nobody really can fill in every single blank. That doesn't mean we can't prove reasonable doubt. But I also think that one of the ways in which he is going about sort of showcasing the unlikelihood that she would have done it is that she'd never done it before. But then you got to go back to that 10 shots. You know, you work with the evidence you have, whether you're the prosecution or the defense. One point I want to make, and I actually thought one of you was going to ask me about demeanor. Demeanor also matters in front of a jury. Is sometimes a jury is literally sort of lulled into a side of the story that's more appealing due to the way that it's presented. The demeanor that the defense attorney has is more of an angry demeanor. Now, I can't see the jury. None of us can. Wouldn't that be something to see how they're really perceiving and how they're open to hearing the argument expressed in this fashion? He's just out of the gate. Maybe it's going to mellow a little bit, or maybe given what he is looking at and their expressions, he feels like a more forceful presentation of a summary of the evidence is warranted. But let's see how it works.
Let's see. But I also think, Michael, I like that he's pointing out some things like there's nothing to support the theory of the scene was altered by the defendant, because he said shells could have been kicked around. I even said, okay, what'd she do with the sock? We never heard that.
Well, that's where common sense come into play.
Yeah,
right?
that's a really great point. Absolutely. All right, thank you so much, Wendy Patrick, for joining us this hour.
Folks, coming up, more closing arguments in the protective grandmother murder trial for Pamela Bordeaux. We'll be right back. Keep it here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. Ahead this hour, jurors had the day off today in the killer or cover-up murder trial, but testimony outside their presence could be pivotal in the case against Karen Reed.
And a day after Pamela Bordeaux took the stand to try to convince the jury that she killed her ex-son-in-law in self-defense, that same jury will soon be deliberating her fate. Pamela Bordeaux is accused of shooting and killing Sean Babbitt in 2019. He was the ex-husband of Bordeaux's daughter. Well, today, both sides are presenting their closing arguments to the jury.
While the defense continues to push self-defense, the state says no, it was murder. Let's get you back into court where we left off. Defense attorney Eric Farron is continuing his closing argument.
Back and forth and learning. That's who I am. I have a degree in biology, and I told you the way I solve problems, which wasn't done here. I metro, right? You have a theory. You maybe have two theories. They're called hypotheses, right? And then you collect data, right? Not by looking at the threshold, folks, but by digging in, right? This detective, I don't know what was wrong with his theory. His theory now, right, is that somehow she's at the top of the stairs, shooting from behind, right? Folks, how many people did we hear from that talks about how this gun ejects, right? If she's at the top of the stairs, first of all, don't you just think Erica here's a little bit better? She's right next door. She's right behind these paper-thin walls that you all know are comprised of the construction here, right? Right next door. You don't think she hears something different? You don't think she hears more? Right? Hey, there was one shot up top, and then I heard, it looks like some more faint shots down there. That wasn't the statement. And again, I thank the state. Because even though Miss Bordeaux has no duty to retreat, we'll get into that. In her own home. In her own home. Defending herself. Defending her grandchild. Right? Defending her only daughter. Right? By the way, is in that bedroom, in the direction she's shooting. Right? Do you think somebody who's never fired their gun in the line of duty ever, right, give the most heated of situations, right? I'm sure many people came on her, and she never did it, right? Do you think she would have ever taken that risk unless she felt that she had to, right? With her grandchild, her daughter, potentially as targets of an air bullet, right? There was no time. This idea that this was premeditated, deliberate, again, it's a red herring, right? There was no time. You heard from her. You all know, when you pick the jury, many of you own guns. You know semi-automatic. Doesn't take long to fire 10 shots, right? And what Ms. Fleck avoids, right? And this is the beauty of the state's case, is they want you to look here, right? But what you should be looking for is everywhere, in the body of evidence. Even the neighbors say, there's 2 sets of shots. Right? What does that tell you? Just sit back and use your common sense. You know, Ms. Bordeaux said she was in it. When you're in something like that, your chance of recalling it, what happened was so sudden, so quick, she did the best she could. She got up there and braved the storm, right? The onslaught. What did she do? She lose her cool? No. No, she was polite. Ms. Fleck, that's just, it's really not what happened. Put words in my mouth, because that's what the state does. That's the only way that they get to try to trick you, right? Because their own CSAs, right? They don't put the crime scene. I know you guys have seen me diddle around with this crime scene forever, but it's their image, right? It's their image, folks. And first of all, again, you want to talk about this detective, the lead detective, who really didn't call anything, and I don't know where he's coming from thinking shots were fired up top. And this guy rejects to the right. There's evidence in the kitchen that would be found if there were shots fired up there at the top of the stairs, right? What's they gonna ratio? There's nothing out there but empty space in the kitchen. Do you think this woman, who by all accounts loves her grandson, her daughter, takes a shot that close in a deliberate manner? Come on. You know better than that. You know better than that. You wouldn't do it. Right? So, and that didn't abide by any of the protocol of the business. And again, I'm glad, right? The state shows you that there were so many visits because these parties agreed to this protocol, right? And it's followed. But if you look at just some of those ring cams, you can see, right, what they don't want to tell you, right, is that Pam rushes to open that door because Sean is right on her ass. Seconds, right? So that day, right, she's down there, she's getting separation. That is the protocol, right? But what the state doesn't tell you, and here's the thing, the beauty of their case, they put on a case, right? It's not a great case, I can tell you, because if it were, they wouldn't need to mess around with this last minute Hail Mary of crime scene alteration, right? When all of their people, all of them, right, including their rebuttal witnesses, said they never prepared reports and it was unsupported by any evidence. And you know, and let me be besmirch this idea. Oh, she's in there waiting on the house, right? She's in there 26 minutes. Oh my gosh, she must have altered the scene. We know that's not true because we know that 911 calls place at 8:02. 8:02. There's no delay. This incident happens. She's not happy. She's in shock. She goes upstairs, makes sure everything okay. She checks on her grandson, on Erica. Advises Erica to call 911. She does. 8:02, not 8:15, not 8:10. Again, don't let selective evidence fool you. You promised me. You promised me a couple of things. Number one, you promised me that if you had conviction, right, you would hold out. You would stick to your guns if you knew what was right. Either way, I didn't put guilty, I didn't put innocent in your mind. I said either way, you would stick to your guns. You remember that? I do. And you also told me to be fair and look at everything, not just whatever exaggeration of shots they want to concoct now. Right? By the time Mr. Blanc gets up, there might be 15. Who knows? Right? There might have been someone on the grassy knoll. I don't know what they're going to say, but that's not evidence. The evidence you have in front of you is plain. It's simple. And guess what, folks? Each and every one of their own detectives and experts admitted to it. Right? It's no secret. Like their own CSA, Miss Payne. I almost wanted to make a joke because there's a rapper named T-Pain. Right? I didn't do it, but her name was Tabitha Payne, I think. Yeah, I was polite about it. But I will tell you this. We sat there, man. I did movements in front of you, and she conceded. She agreed. It looked like somebody was backing up. Right? Not lunging forward, not going to get him, backing up. Consistent with exactly what she said. Right? It makes absolutely no sense. And they don't have an explanation, so they don't really try to explain it, other than to say it's amazing. Right? Oh my God, all these shells end up in one area. Well, what do you think that tells you? You could use your common sense on a gun that ejects to the right. I explained it for you, right? And I got it in through their own witness who didn't want to admit it, right? They brought it in for rebuttal. Detective Hodson. He probably did. He was in charge. This is the guy, okay, in charge of the collection of the evidence. Give me a break. This guy gets up there, and said, oh yeah, there was casings, cartridge casing right under his shoe, touching the shoe. You know, to remind you folks, must like that duty belt they made a big deal of, which really was a tool belt, right? Every little thing they say is calculated to inflame you, right? To get a rise out of you. That's not your function. You promised me even kill, fair, and consider the evidence, right? Not some statements about, you know, some last question. You saw it yesterday, and I lost my cool. Because you should lose your cool. Because the last couple questions from Mr. Bilal were, how do you think somebody would manipulate this? What would you do next? Come on, folks. To blurt that out, right? Well, we conducted a trial, and I have done my best to give you, right, the full story. Blocked in every way by the state, right? Nudging at every corner, right? Little jabs, right? Just to fool you into something, right, that this isn't. This wasn't a happy guy, folks. This was not a happy guy. This was the guy, like I told you, you heard it from Erica. This is the guy who tattooed his wife's name on his wrist. On his wrist! After the divorce! Is that a happy guy? Or is that a guy who wants to get his family back? Right? Who's not getting his family back? This is the guy who sat in some lawyer's office, right? Who didn't call, right? And sat there and signed a document that said he would only see his son one time a week for 1 hour. Nobody forced him to. I have 3 kids. We just had Father's Day. If I showed you the text messages, I told my son I was proud to be his father, right? And I cried, and I will tell you this, it was one of the most emotional moments of my life. And I thought about this case, and I thought that I would never, ever, you would have to kill me, right? And that's what they're gonna try to say happened. Is that didn't take any pressure, didn't take any force. He sat there and he signed a document essentially giving away his rights. Now the funny part about it is you can use your common sense, right? And what does your common sense tell you? There must have been an issue. There must have been a reason why these precautions were taken. That's not customary, folks. You heard it from Ms. Dawson herself, the attorney. Right? And they want to try to fool you and say, some letter, after 4 years, and if you heard from Erica, this guy hadn't been doing what he's supposed to be doing, right? Hadn't given her proof of any of the therapy records, right? Therapy. Think about that. You can use your common sense, your life experiences, that's what the instructions say, right? You can understand and think back there, why a man would do this, why a man would agree to supervised visits.
Judge, I'm going to object at this point. I think that we've gone real far afield.
You can think about a lot, Judge. I didn't say why.
I don't know what he's talking about.
Ultimately, at this point, that there's something that found evidence in front of them, which is improper. So this is no rejection.
Fine. Maybe, Judge. So, again, we look at evidence. We don't have to guess, right? We look at their own protein atlas, right? Which talks about.
All right, before we head to break, we do want to bring you an update on a story that we've been following for a couple of months here at Court TV, the disappearance of college student Riley Strain.
Strain's family finally has some answers after an official autopsy determined that Strain, whose sudden disappearance made national headlines in March, died an accidental death as the result of drowning and alcohol intoxication. His blood alcohol level was nearly triple the legal limit.
The University of Missouri student was last seen on March 8th after being escorted out of a Nashville bar and away from his friends. Authorities say he was last seen alive and alone at the underpass of the James Robertson Parkway Bridge.
2 weeks after he was reported missing, Strain's body was found and pulled from the Cumberland River. The medical examiner was able to quickly identify him due to his clothing and other identifiable objects on his body.
A private autopsy on Strain's body also revealed that there was no foul play. All right.
We need to take a break, and we will get back to more. The defense's closing argument up next in the protective grandmother murder trial. Stay here with us on your front row seat to justice.
Tonight on Closing Arguments, a deep dive into the case against Karen Reed. We're breaking down the biggest moments so far and looking ahead to what's next.
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on Court TV.
What did you feel?
I was going to strangle me to death. The way he looked, his demeanor.
And just so the
He was
jury
coming
understands.
fast.
Right, so the jury understands how long did this entire incident take?
Seconds.
That was defendant Pamela Bordeaux testifying in her own defense yesterday in the protective grandmother murder trial in Las Vegas.
Closing arguments are still continuing, but before we head back to court, let's bring in trial and civil attorney and Temple University law professor Dante Mills. Dante, here's what bothered me. That defense attorney started yelling really at the jury. I felt like it was not useful. It was more jarring and jolting, and I think you have to be really careful during closing not to offend the jury.
Absolutely. And when I'm talking about, even with my students, about summation, there's an expectation that there's going to be some passion there, but that has to be measured. And if there's maybe one or two things that you really want to bring a point home, but he was consistently yelling, where it was just kind of jarring. And it also loses the focus or loses the point of what he's yelling about if he does it over and over again. So I was really kind of taken aback by his presentation in the closing argument. I think this is a tough case. This is the case where the defendant actually testified, and we don't see that often. I think when she testified, her demeanor was, I guess, the opposite of her attorney in closing. She was very calm. She's a trained officer, a detective. So for her to, panic or anything in that situation, I think it's going to be a hard sell to the jury. But I think that her attorney needs to kind of let the facts speak for themselves and not try to overwhelm this jury or just shock them into a not guilty verdict, because that's not really the way you do it.
Yeah, that's a great way to say it, Dante, because it seems like he's trying to shock them into doing what he wants them to do.
Agreed.
And I think, it's okay if you pick your spots. But like you said, he's doing it so much that you're losing really the stuff that he's talking about. One of the things that I thought he hit on that was actually very good was because of evidence, rules of evidence, they couldn't get in front of the jury why this woman and this family didn't really like this guy. The fact that he was a sexual deviant, at least according to them, and a porn addict. But he did mention to this jury saying he only had 1 hour a week of visitation. And I thought that was something strong, because the idea is, well, if a guy's only getting 1 hour a week of visitation, the implication is maybe he's not such a great guy, and that's something he had to use in his favor.
Absolutely, and I think it was absolutely intentionally inserted so that the jury can believe that there was a reason why he was not allowed to see his children other than that 1 hour. And speculation happens. The jury is going to be sitting there thinking, what did this guy do so bad that the court system or child services would not allow him around his child more than 1 hour? And there's going to be assumptions made. I don't know if that raises to the level of he's worth being killed, or that the situation was so dire that murder was necessary, but it does create some questions in the mind of the jury, and it was a very artful and craftful way for him to get that information out there, because they were limited in what they can talk about the victim's past, which I believe was the right thing to do. I don't think pornography has anything to do with this situation, but this is a way for him to plant some seeds of doubt in the jury about who he was as a person.
Yeah, and he's got to use everything he can, because I agree with you, Dante. This is a tough case based on the facts as they are right now. All right, stand by. I want to go back into court now. Defense attorney Eric Ferrin is still in the middle of his closing argument. At times, he's been pretty animated, to your point. All right, let's get back into court.
She didn't have a duty to retreat in her own home. Why would this woman do this on that day? Like, over a letter? A letter, right? Not a motion. You can have a stipulation. We all agreed to back there, right? For all the scuttlebutt. For all the scuttlebutt. You know what that stipulation says? That Miss Bordeaux, remember in taunt, that Eric isn't here. In fact, any lawyers for that matter, you didn't hear anything like that. In fact, what you heard about my client universally wasn't that she'd be angry and aggressive, right? You heard that she was accused of making an insurance claim, right? And they want to, again, cover it up. Let me tell you, despite the fact that Detective King said in the affidavit that he was looking for financial motives 9 months after the fact. Come on. Give me a break. You know why they're looking for books? You know why? They didn't buy their own motive. Nor should you. Because even Ms. Dawson said, there's no guarantees. So, sure shot. They hadn't even filed a motion. What do you think was going to happen? Court discovery. As Erica states, that's the only evidence of any completion of any obligation of that court order, but she hadn't gotten it. She hadn't looked at it, she hadn't seen it, right? This wasn't a slam dunk of modification of custody, right? And you remember what I called it's baby steps. My experience in family law and hers, she knows it's baby steps. What reason, right, with this woman who spent 23 years on the force, 5 years before that in the military, trusted by the very people who are trying to lock her up now, rush to judgment, right? Evidence not collected. You got a peekaboo detective, right? Taking a little peekaboo. Oh, this must have been the motive. We're done, folks. And you know, it's like who's on first, right? Nobody is talking to anybody, right? Their own entry team talks about this being a close battle, right? They miss evidence. Admittedly, they kick around evidence. Nobody, I submit to you, is going to kick around that much evidence. The only way, if she just get into the bathroom, is because she's backing away. She's trying to retreat, but the reality, folks, is that you have a couple of seconds. And according to the neighbors, there were 2 different sets of shots, right? That's what they heard. You can go by that. Ms. Bordeaux has no recollection. This happened so quick. 5 seconds tops. This isn't premeditation. Right? Think about a guy who agrees to that and talks about it. But think about, go further. Take it some steps further. Now think about a guy who gets married. You know? I don't know what kind of relationship you have with your mother-in-law. My mother-in-law didn't invite me to her home for 6 years rent-free. I had to bring her to my house rent-free. And that created a little tension. 6 years. So that Erica, so that Sean could excel, could move up in life. And that's what they did. They got degrees, they got certifications. Who does that? Who does that? She wanted him and her to succeed in any and every possible way. This wasn't a question, folks. This is fact. You want to talk about habit? Talk about a woman who does this, who absorbs this, while she continues to work and serve this community. To be trusted by this community, right? Without any incident of this nature. A woman who's never discharged her firearm at another human being until this incident in her own home, where the evidence suggests, right, that she was backing up, that she was cornered. There's no other exit, folks. Do you think that a woman who's 5'1", 5'2", 100 pounds, going up against Sean, outweighs her probably by close to 100 pounds, and a foot taller than her, coming down some stairs running? Do you think if she perceived that, there's any way out for her? Right? Whose story makes more sense? Right? Who is more likely to be the aggressor here? A woman who has never done that, right? Or somebody lost the love of his life, Erica, right? To Chris Cornell, right? Chris Cornell, I couldn't think of more than a slap in the face. If you told me that my wife had left me from my boss, right? And then I couldn't see my kid, right? Because my boss was taking care of my kid. Man, just think about that for a reason. And it's just for a minute. And give some time to percolate when you're back there, right? Does that make a recipe for a happy guy? That's a powder keg. Right? And then her testimony for Erica, right? After the divorce, we're talking 2-3 years later, he's still paying her flowers.
All right, the defense really focusing in on the victim in this case. Again, we've seen that backfire before, but they're not done yet. So when we come back, we're going to get you right back inside that courtroom. We're hitting that pause button. Keep it here on Court TV, your front row seat to justice.
When you're...
Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. We're continuing our coverage in the protective grandmother murder trial in Nevada. The jury could soon have the case against Pamela Bordeaux.
She is accused of shooting and killing her ex-son-in-law in April of 2019. Right now, the defense is continuing its closings. Let's get you back into court. We hit that pause button.
When does that stop? When does it stop? When she's got a baby in prison. Right? Listen, I don't know about you all, but that's like something I'm so wrong about. You know how those things go. Right? Anger, rage, jealousy. Think about it. Think about it. You don't use your common sense. Right? You can think about it. About what would been going on, right? Certainly not a recipe for happiness, right? That's when everything changed. You go out with this lawyer, you hear from her, you hear from Marcus, that he's been, a little arrogant, right? And then they want to rope Pam in on this, right? On a letter. This lady, who kept it cool up there, tried to explain everything to you in a calm and collected manner, right? As she was attacked, right? Attacked. And what I mean, she is a de-escalator. Now Marcus, yeah, you heard a lot from Marcus, right? Marcus had been involved in an incident, right? Marcus himself testified that he had thought he had gone back home and come back and given a statement. He was all over the place. He liked us. Whatever, liked him, right? You can tell, because when she's angry, right after this incident, he's hugging on her. She's not hugging on him, man. She's in handcuffs. And guess what? Her own peers, well, I didn't really do anything about it. You want to know how much Pam's trusted? Even by those who are now trying to put her away. They didn't even pat her down. Man, they sat her in the car for a 10-mile drive, right, with handcuffs, and her holster's still in. They didn't even think about it. That's who she is, and that's who she was, right? She didn't have breakdowns. Who is more likely to have been the aggressor that night, right? She's got nothing to hide. She came up here before you both, and I told her she's the bravest person I know. She had nothing to hide. She answered every question. She would have answered any question. That's who she is. She has been waiting patiently for 6 years to tell her story. And why do you think we're here? I'm not asking you for some voluntary manslaughter or a second-degree murder conviction. This is a justified killing. The evidence shows it. Their own initial perceptions, their rebuttal witness. Not at first, well, no, I don't know. Now I'm a detective, and I'm going to be real difficult, right? And I'm going to tell you things that are just going to fight you. Yes, Ms. Flack, anything you say. Okay? That's not what we know. What we know is what she said, right? What she said, this was Thomas. What the only CSA said, right? And Pearson was backing up. Firearm was edging to the right. You're back into that corner. Dead space. No exit. She had no choice. She tried 2 sets of shots. Right? And this guy kept coming. A big guy. Right? So this idea, like, Mr. Fleck suggested it was execution from the top of the stairs. It's not supported. That's not evidence. Use your review. Right? Listen to the testimony. Think about what was said and how this ended up like this. Because I can admit to you, that opened at 8:02. And we heard from everybody. There was no tampering with it. Right? You think about Mr. Babbitt and what he had been through. Right? They want to show you a happy Elton John song. That's not life, folks. That's not life. It can't be life. You see your kid once a week. When you're divorced and your wife marries your boss. That's not life. You know? And I want to show you again, every little step, every little question, right, is only designed to inflame you. That's not evidence. But they don't like to show you evidence. Don't put it up here. We don't do that. Like I said, Nick? This is how it don't get old. Right? You don't get these kind of injuries, right? Unless you're coming at someone. Right? That's not a right? That's a strangle, right? And that's a big dude coming at her in a tiny space, according to their own now detective, right? If that doesn't do any doubt for you, I don't know what does. And that leads me, I want to go over, right, one of the instructions. But you're going to have that, you have all of them. If you find, it's not so hard, let me try to zoom in here. Right? This is number 24 on the set. It says, the evidence of self-defense or defense of others is present. The state has to. Again, there's no burden for Ms. Bordeaux here. Pam has no burden. Pam she comes in here clean. Right? There comes with a fair shake. And that's how you go back to the deliberation. Right? The state must prove, the state, beyond a reasonable doubt, that she did not act in self-defense or defense of others. If you find that the state has failed to do so, beyond a reasonable doubt, you must find her not guilty. If you believe this could have been self-defense, and you put on evidence, you listen to her testimony, and you don't have to just listen to her testimony. You listen to the corroboration of each and every person they put on. In close quarters, their own CSA, they know. Why do you think they're coming up with the last minute defense? Right? If they had that, folks, I mean, that's one of those things that you bring up right at the beginning, in your opening. Right? And you say, Ms. Bordeaux not only did this, right, but had the wherewithal, the time, and the intent to alter the scene. I don't know about you folks. I didn't hear that in their opening. This is a last-ditch effort to fool you. Right? You're gonna go back there, use your common sense. Listen, really sit and listen, right, to what you heard. Now, you heard me shred all of the witnesses. Right? Again, you can see things, right, like that Francine diagram. Right? Like the fact that it was into the heart.
All right, we want to hit the pause button to tell you about a new case that Court TV is following. A plastic surgeon in Florida has been charged with killing his wife while performing cosmetic procedures on her last November.
Investigators say Hillary Brown was at her husband's office to get several procedures, including liposuction on her arms, lip injections, and a procedure to strengthen muscles. Well, Court TV secured the administrative complaint from the Florida Department of Health. And according to the complaint, Dr. Benjamin Brown failed to properly document medications that Hillary was taking, including Valium. The filing also indicates that Brown allowed Hillary to assist in her own muscle procedure by suturing the skin back together. Now, during that time, investigators allege Hillary became restless and her feet began twitching.
But despite those signs, officials claim that Brown continued performing other procedures and even injecting Hillary with more anesthesia. Seized it. Why can I not say that word?
Anesthetic.
Thank you. Investigators say Hillary eventually had a seizure and became unresponsive. The document also states that Brown waited 20 minutes before doing CPR and calling 911.
Just incredible. Now, Brown is charged with second-degree felony homicide. The Florida Department of Health suspended Brown's medical license last month, citing Hillary's death and other instances of alleged malpractice.
Yeah, stay with us. That's a heck of a story, Michael. It's pretty unbelievable. Yeah. Anyways, when we come back, we're going to get you more of the defense's closing argument in the protective grandmother murder trial. We'll hit the pause button. Keep it here on Court TV.
Wednesday.
The ultimate betrayals.
Back-to-back episodes of Accomplice to Murder.
The spell was broken when the handcuffs went click.
Friends and family turning on each other.
What he was willing to do for $1 million.
But just who is the puppet?
She was a master manipulator.
And who's pulling the strings?
An Accomplice to Murder marathon. Starting Wednesday, noon, 11 Central.
Only on Court TV. Welcome back, folks. We'll get you back to court in just a minute, but first, let's bring back in trial attorney and civil attorney and Temple University Law School professor Dante Mills. Dante, I want to ask you about her position as a law enforcement person, but also as a military person. She's got a background in guns. She's got a background in dealing with these kinds of situations. And my question is, do you think that's going to help or hurt her? Because she was very, I don't want to say matter of fact, but the way she delivered this whole incident, there wasn't a lot of emotion. And that could just be part of her personality, but I wonder if it could hurt her in the long run.
This is such a good question because whenever you have a fact pattern, you know I always talk about controlling the narrative. You can paint the picture around what it's supposed to mean. I was listening to this summation by the defense attorney, and he talked about her military background, her being an officer, and saying she was trained. She knew what to respond to. She knew how to handle herself. She wouldn't have taken action if it wasn't necessary. But then about 2 sentences later, he talked about her being a small woman, and how I guess she would have been afraid and a big guy was coming towards her. So there's an opportunity here, and I think there was for him to really lay it out that she knew how to respond to situations and that she only acted because her training told her to act because it was a dangerous situation. But he kind of took away from his own argument when he tried to say, oh, she was frail and he was big, and that's why she responded. So I think this defense attorney has to pick one side. He should have picked one side and went with it. And I would have went with the side of she's a trained professional and that she would not have taken matters into her own hands unless it was absolutely necessary. She doesn't have a history of this with the department. There's no indication that she's just a loose cannon and that the only reason she took action here is because it was required. And that's the argument that I would have taken. And I think it would have really hit home with the jury.
Well, and he's kind of all over the place, let's be honest, during his closing, so it's not real succinct. But having said that, we want to hear more of what he has to say. Let's go back into court for the rest of his closing argument.
How can these people be trusted? What is going on here? Right? Why the rush to judgment? It's like I told you. Right? They solved it one way. Right? Instead of sitting back, checking out, coming to a conclusion, whatever it was. Right? That's the right way to do it. That's the scientific way. That's how I learned. I work in the labs. I have a biology degree. That's how you solve it. That's the whole scientific method. I wish Metro had used that in this case. And I wish the state had a better case. Rather than coming up with some magic formula on the last day of trial to keep the wool over your eyes. Right? Use your common sense. Think about the environment. Think about the state and what they don't want to show you. Right? Because that's just as important as what they did try to show you. They showed you 4 ring videos. 4. She must be guilty. 4. Right? Out of 154. They're not showing you the entire picture. Right? What's wrong with that? What are they hiding? They know, I know, and you know, right? Miss Bordeaux is innocent. Right? She's presumed innocent, and the evidence certainly creates doubt. so much doubt, not only in their methods, their practices, what they did on this scene, their recall, their flippant lies. Right. This guy, the guy who's in charge of evidence, right, offers up that this car has been found under some shoes. Right? And by the way, folks, you heard a lot about contact DNA transfer, right? You heard from that they needs to be transferred. They don't fill up that duty belt, right? That's testing on academics, right? DNA. They don't collect shoes. It's right in their cartridge. By the way, there's no other guys living in the house, right? Miss Bordeaux's alone, single. Erica comes over for the visits. Mr. Carno's not there that day. Those shoes are Sean's. Look, the shoes, they're right next to all the little clean and markings. Why not take those shoes? How sloppy can they be? That's spearheaded, again, by a guy who's so committed to solving this crime in a fair way, right? This event that in the little house, right? They're declaring her guilty of first-degree murder within the hour. Within the hour. That's one of their own. Can you imagine what they would do to others within their own home? She had no duty to retreat. None. The evidence suggests self-defense. Now I ask you, as a state, really, other than statements from Ms. Fleck and outlandish accusations from Mr. Ball, have they proven beyond reasonable doubt that this wasn't self-defense? Have they proven anything? Have they proven this was deliberate, intentional? I don't think so. I think we're going to tell them it's okay, right? To tell them that you know, to stick to your conviction, to use your knowledge and experience, and go to use this evidence to show them that you know who Pam is. That Pam had been given this whole time to give your story. By all accounts, she had no involvement with money. She had no involvement with lawyers. To suggest that somebody who behaved in this manner throughout her life didn't need the money. Right? Who had a great job, performed well in it, retired, wasn't fired, didn't hear anybody get up there other than Miss Fleck and say she's a bad person. Not one person testified about anything negative about Miss Bordeaux. Nobody. In fact, everybody, even Marcus, who they're trying to use as their star witness, a confused, rattled guy, right? Who misbehaves at the scene and miraculously doesn't get in trouble for it. I can't think of anyone who would go hug a potential suspect at the scene and not get in trouble. Nothing happened, right? It doesn't make sense to me. It should make sense to you. I would submit that if you go back and look at all of the evidence, right? And it wasn't a Pam's testimony. So the only testimony of the incident, right? And it's actually supported by their own witnesses. Supported. Sit back and lay it all out. Right? There's no evidence of any movement upstairs, right? We know that. We know Pam loves her family, right? And she would never, ever, ever have taken a shot that would put them in danger. We know that everything corroborates exactly what Pam stated to you, right? She didn't know how many shots she fired. I asked right here in front of you. And I said, hey, we all want to know. And I want to know, right? It happens fast. It happened in 2 sets. She tried. He kept coming. This guy was a lot bigger than her. In a tight space with no exit. What would you do? If they